In no uncertain terms, the U.S. Constitution bars someone who has engaged in an insurrection against the United States from holding public office. So, why does the Supreme Court seem poised to let former President Donald Trump remain on the ballot, despite his involvement in the January 6th attack on the Capitol? And what happens if and when they do? To discuss, I'm joined by Josh Gerstein, Politico Senior Legal Affairs Reporter and Spring Resident Fellow with Harvard's Institute of Politics, and Jeremy Pohl, former Dean of Northeastern School of Law, where he's currently a professor of constitutional law. Jeremy, help me out. What does the 14th Amendment actually say?
The 14th Amendment explicitly says that no person shall be a senator or representative in Congress or elector of president or vice president, or hold any office, and that's the key phrase there, who having previously taken an oath as a member of Congress or as an officer of the United States, and I'll skip on, who shall have engaged in insurrection can hold any office. And you raised the question perfectly in your opening, what is it about that language that's unclear? And unfortunately, there's a lot that's unclear. The single biggest thing is who gets to decide whether someone has or has not engaged in an insurrection.
So who does get to decide that, Josh?
Well, I mean, as Jeremy suggested, the first thing I think any of us trying to interpret this would look at would be, well, was there an insurrection? As a reporter, this would be my instinct, and if so, who was involved in it? And the weird thing about this is that seems like the question the Supreme Court is least interested in grappling with. They are more interested in all the packaged questions around it about who this applies to, whether the way this came up with the Supreme Court, where it came out of Colorado and the decisions of a Colorado courts on this issue are things that the Supreme Court needs to recognize or that other states need to recognize. All those ancillary issues are ones that the justices seem much more interested in debating and discussing than whether there was an insurrection on January 6, 2021, and whether the then President Donald Trump was responsible for it.
So on the question of if there was an insurrection, I mean, Senate Minority Leader Mitch McConnell, a Republican, he had a speech on this topic where he said,
"It was a violent insurrection for the purpose of trying to prevent the peaceful transfer of power after a legitimately certified election from one administration to the next."
Okay, so Mitch McConnell says it's an insurrection, and we don't take Mitch McConnell maybe as the final word on these things. But interestingly enough, Donald Trump had an opinion as to whether January 6th was an insurrection as well, too. And so we could hear what he had to say about it.
They kept saying about what I said right after the insurrection, which I think it was an insurrection caused by Nancy Pelosi.
So apparently the one thing none of us are going to argue about is whether it was an insurrection, because Donald Trump says it was, and I guess he'd be the person most motivated to say that it wasn't. So what is the source of confusion in the 14th Amendment that makes it less than clear?
The trial court also found that it was an insurrection, and they relied heavily on the committee hearings from the January 6th committee. But there's been no formal process, so Mitch McConnell can say one thing, former President Trump can say one thing, but the question is, what sort of formal process must be undertaken in order to determine whether it was an insurrection or not? I have my own view. I think, of course, it was an insurrection. But what the Supreme Court is looking at is how many different people should be able to express an opinion on that. If one state says one thing, another state says another thing, the justices seemed, at the oral argument, very concerned about the possibility of different states reaching different conclusions.
So, I mean, is there the possibility of a formal process to determine this, or is the Supreme Court just trying to get out of answering an awkward question?
Well, there was a bit of a process already. There was a trial in Colorado. It wasn't a jury trial. It wasn't a criminal trial. It was just a single judge sitting there hearing evidence. As Jeremy indicated, a lot of the evidence she took in didn't really come in her courtroom. It came at those House hearings, which she sort of deferred to. There were a few witnesses, Capitol Police officers and others who came up. And a lot of the evidence is on the record on C-SPAN. You can go and find Trump's speech on the ellipse from January 6, 2021. So there was some fact-finding here, but it still doesn't resolve the question of what if another state did this a different way. This is usually the kind of trial you might have on a question of whether a candidate is a resident of a place they need to be a resident of in order to run for office. So it's not the kind of thing you would convene a jury for typically to resolve. So that's one of the questions the justices are squabbling with or trying to resolve in this particular situation is, should they defer to what Colorado does? Should they defer to what Maine does? There's a bunch of states that don't want to address this question whatsoever. Is there some role for the federal courts here, or is this something that each state can just go ahead and do on a state-by-state basis?
Yeah, let me add, there's a strong historical argument that this should be decided by the states. In other words, the idea that different states reach different conclusions, different states vote for different candidates, and we don't worry about that. Different states have different voting rules. We don't worry about that. So the concern expressed by some members of the court that confusion would reign seems to me overstated, and they easily could, had they chosen to, taken a different tack. But it looks as though, from listening to the argument, as though President Trump will prevail and he will be on the ballot.
I mean, I'll just note that in 1860, when Abraham Lincoln ran for president, he did not appear on the ballot in most southern states, and we did not decide that his presidency was invalid because of it.
Fair enough.
So I'm just sort of trying to understand where we are, because, okay, the 14th Amendment imposes one qualification on being president of the United States. You cannot have tried to overthrow the government, and we could say that's one. But it is not the only qualification the Constitution imposes. It also says that you have to be a native-born American over the age of 35. If a 34-year-old runs for president, who has the power to say that she is not allowed on the ballot?
Well, that's one of the issues that came up at the argument. And I think that voters in Colorado would say that the Secretary of State in every state, under state law, should have the power to make that decision. But some other people now might suggest that it ought to have to be Congress to decide that. But again, each one of the various qualifications, you mentioned age, which is another one, being a natural-born citizen is another one, all those things. Do we have to have the same mechanism for deciding for each one, or could we have a different decision mechanism depending on how open and shut it is? I think one of the things that the court felt, or at least some members of the court, was that the question of what age you are is open and shut. Now, that might not be true. We could have conflicting birth certificates, but in general, it's pretty clear. Whereas the question of whether you did or did not engage in insurrection is much more, according to some members of the court, open-ended, needing further consideration. I think that, I don't know how you felt about that.
No, I agree with that. I also think we probably should hesitate to look at this in a completely on-the-level kind of way, by which I mean it may be that it isn't strictly legalities that are here on the table with the Supreme Court, but other concerns. You might call them political concerns. You might call them concerns about the court's legitimacy if they were to take a candidate off the ballot for whom tens of millions of people apparently want to vote for, if you believe the opinion polls. And there are people who think that what's going on here is sort of what some have termed a grand bargain with the Supreme Court, where they're likely to rule that Trump can remain on the ballot, but they're also facing a case that's coming to them probably today that has to do with whether his criminal trial on charges of trying to subvert the 2020 election can go forward. And one possible outcome here is you might see a broad consensus on the Supreme Court to let Trump remain on the ballot, but in some fashion also let his trial go forward, and that would be seen as a way for the court to avoid appearing to have put their finger heavily on the scale in one direction or another on what is usually a political choice for Americans.
So the immunity trial, I mean, has a particular set of claims, and I don't want to let them go because Trump's attorneys made a kind of remarkable claim of the level of presidential immunity they were claiming to the president, right? At the level of assassinating a political opponent, if we could hear that for a second.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to seal Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
But if he weren't, there would be no criminal prosecution, no criminal liability for that? Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first.
So, I mean, Donald Trump's answer, his attorney's answer, which he tried to dance around with great desperation, but it's pretty clear his answer was no, right? He could not be convicted for that. Can we imagine a Supreme Court saying actually presidential immunity extends that far under any circumstances?
I could imagine maybe a couple of justices taking that position, and we do have some justices that are very strong believers in executive power and the needs to have a very agile and robust presidency. But candidly, can I imagine them taking it quite as far as that? No, I can't. And even in past occasions when they've had to address this sort of issue, even involving Trump and his other interactions with the criminal justice system before these current charges, they've pulled back from the brink a little bit and ended up with kind of a compromise answer that said, well, some of the things that a prosecutor is interested in doing would be okay, and we're not going to accept your absolutist arguments on this.
We shouldn't even have bothered to revolt from the King of England if we were going to accept a position like that. I mean, what was the point? That position is ludicrous under American law.
So just to push on the, not that immunity, but then if we're all structured in this sort of elaborate question about the presidency and how far its immunities thing, whether you're allowed to run, whether or not, you engage in insurrection. I just note the only time I ever met Justice Scalia, many years ago, I'll never forget what he said to me, which is, most of the time my job is very easy. He said, most of the time my job is very easy because I believe in the plain meaning of the text. And most of the time the plain meaning of the text tells me what the Constitution says, and sometimes it's not obvious, but most of the time it is. We can disagree with that assessment or not, but that was his statement multiple times in that one conversation. So, all right, I think there are places where the Constitution is somewhat ambiguous, but it strikes me that this is not one of them. Right? That the 14th Amendment, the wording is very clear, and the meaning, if you do actually care about what the writers of it meant, they did it in the wake of the Civil War, their meaning was very clear. So it seems to me particularly ironic that the judges who are most committed to interpretations of the plain meaning of the text seem to be the most enthusiastic about evading them in this case.
Well, there certainly is an irony there, and I would not even begin to dispute it. I do think that they have some textual arguments. We've been over them a little bit. For example, as I read before, the list of officers who are in the text includes senator, representative, elector, but not president. And Justice Jackson, in her questioning and during the oral argument, seized on that as a textual hook. But I guess my bottom line answer to that is when Justice Scalia told you that, he wasn't telling you the truth. It really is not the case that it's easy to interpret the text. I think he took some extreme liberties with the text when he ruled that the Second Amendment protected an individual right to own guns. I think he did that frequently, and he liked the text sometimes and didn't like it other times. And I really think that for your listeners, trying to get them to focus on what exactly does one word mean versus another abstracts from what you raised at the beginning, which is the most important question, was what are the framers trying to do? And what they were trying to do was stop insurrectionists, particularly those who were in the Civil War, from holding office. And that aim and spirit seems to apply directly here. And I think it's unfortunate the court's going to let President Trump off the hook. But I agree 100% with Josh that what I think is likely to happen is that Trump will be allowed to be on the ballot, but they will not accept his absurd immunity claims. They might not even take the case because his claims are so weak. And it will allow the court to present itself as one time I'm with Trump, one time we're against Trump, and allow the country to have some feeling as though the court is neutral in doing things on the merits, which ultimately, we have so many people in both parties who have been warning us for years that we have an insurrectionist, a liar, and someone who does not believe in basic American constitutional principles seeking to hold the highest office in the land. And somebody somewhere has to step up and stop him, but this ballot question is not going to be where.
Jeremy, Josh, thank you for joining us today.
Thank you.
Thank you.
Thank you.